If you've got a specific legal question or situation you'd like to see covered here, drop it in the comments, because that's genuinely where a lot of future topics come from. I read them, and some of the most useful specific videos on this channel started as exactly that kind of comment from someone dealing with a real situation, so don't hesitate. Whatever it is, I'd like to hear it. All right, let's keep moving.
You're driving. Maybe it's late, maybe it's not. Maybe you're on your way home from work, or running an errand, or just taking a route you've taken 1,000 times before, and then you see it in the rearview mirror. The lights, blue and red, strobing behind you, in a way that makes your stomach drop even before you've fully processed what's happening. And in that exact moment, before you've even pulled over, before anyone has walked up to your window, before a single word has been spoken, a series of decisions has already started forming that most people get completely, entirely wrong. Not because they're careless, not because they have anything to hide, but because nobody ever sat them down and explained what their car legally means, what those lights legally mean, and what the moment the officer knocks on your window actually is and is not. Here's what I want you walking away from this knowing, completely, clearly, without having to think about it under pressure. Your car sits in a genuinely interesting and somewhat complicated place in the legal framework of this country. It's more protected than the sidewalk you're standing on, but less protected than your home. It comes with rules that feel simple until you're actually living through one of those stops, and you realize the gap between knowing the general concept and knowing the specific words to say is enormous. And that gap is exactly where most people lose something they didn't have to lose. Before we get into exactly what to say, word for word, phrase by phrase, subscribe right now, because this is precisely what this exists for, giving you the real, usable version of your rights. The one that actually helps when it's 3 in the afternoon on a Tuesday, and there's a cruiser pulling you over on a road you know like the back of your hand. Quick note before we go further, this is legal education and commentary, not legal advice for your specific situation, and some rules shift state to state, but the core principles here hold up across the overwhelming majority of this country. Let's get into it. Let's start with the most important single thing to understand. The one fact that everything else in this video is built on top of. When an officer asks to search your car, they are asking, not ordering, not commanding, asking. And there is a reason they are asking rather than ordering, and that reason is the Fourth Amendment. The Fourth Amendment protects you against unreasonable searches and seizures, and in the context of your vehicle, this means that absent a warrant, absent what's called probable cause, or absent some recognized legal exception, an officer cannot simply search your car because they feel like it, or because you seem nervous, or because it would make their job easier in that particular moment. They need either a legal justification they already possess, something specific they can point to, or they need your permission. And if they're asking, it's because they don't already have the first thing. They need the second thing. They need you to say yes. And here is the single most important point this entire video comes back to. You are allowed to say no.
It's interesting, honestly, how often variations of this general subject keep coming up across completely different specific situations over and over. I think that's because the underlying pattern is more universal than people initially assume. A moment of pressure, a question that sounds simple but carries real legal weight, an instinct to just go along with things smoothly rather than pause and think it through. That basic shape shows up across an enormous range of otherwise completely different situations, which is exactly why understanding the underlying pattern, rather than just memorizing one specific scenario, ends up being so useful. Once you see the shape clearly in one context, you start recognizing it everywhere else too. All right, let's dig into today's specific version of that pattern.
No. I know that feels counterintuitive. I know that sitting in your driver's seat, with an officer leaning toward your window, every social instinct you have is pushing hard in the direction of cooperation, accommodation, making this easy, not being the person who causes friction. And I want to spend real time with that instinct, because it's not a character flaw, it's actually a completely sensible response to social pressure in almost every other context in your life. The problem is that this specific context operates on a completely different set of rules than almost every other social situation you'll ever find yourself in. In every other context, agreeing when someone in authority asks makes things smoother and generally costs you nothing. In this specific context, agreeing when an officer asks to search your car can cost you something significant, something you didn't have to give up, something the law specifically built a protection to keep yours. And the reason good, honest people hand it over anyway, without a second thought, is almost never because they thought it through and decided cooperation was the better choice. It's because they never knew, in actual concrete terms, that they had a choice at all. So let's build the foundation before we get to the exact words, because the words work better when you understand what they're actually grounded in. The Fourth Amendment is the constitutional protection against unreasonable searches and seizures. It applies to your vehicle. It means that generally, an officer cannot search your car without one of three things: a valid warrant issued by a judge, probable cause, meaning specific, articulable facts that would lead a reasonable officer to believe evidence of a crime is present, or your voluntary, freely given consent. That third category is the one that's most often at play during a routine traffic stop, and it's the one you have the most direct control over, because whether or not consent exists in any given situation is entirely up to you, not up to the officer. Up to you. Now here's where it gets important in terms of what consent actually means in the legal context, because most people think of consent as something you give when you actually feel okay with what's being asked. The law uses the concept slightly differently. Consent to search, in a legal context, means agreement that you gave voluntarily, without coercion, without being misled about whether you had a choice. It doesn't require enthusiasm. It doesn't require that you be happy about it. But it does require that you actually agreed, that you said yes in some form, and that the agreement was genuinely voluntary rather than extracted through pressure, confusion, or a deliberate misrepresentation that you had no right to refuse. This matters because courts do look at the full circumstances when evaluating whether consent was voluntary. But here's the practical reality. Those evaluations happen later, in courtrooms, often with imperfect memories and conflicting accounts of what happened at the side of the road. The cleanest, simplest, most reliable way to protect yourself is to decline clearly in the moment, so there's never any ambiguity about whether consent was given at all. Let's walk through the actual stop, step by step, from the moment you see the lights to the moment you drive away, because the sequence matters and the details at each stage matter. The moment you see lights, signal, and pull over to the right as smoothly and promptly as you safely can. Don't stop suddenly, don't pull over in a dangerous location if a safer one is close, but do pull over promptly, because unnecessary delay creates its own complications. Turn off your engine. If it's dark, turn on your interior light. This is one of those small things that cost you absolutely nothing and removes one layer of potential tension from the encounter before it even begins. Keep your hands visible on the steering wheel, and don't reach for anything until you're asked, because the moments before an officer reaches your window are ones where visible, calm hands matter more than almost any other single thing. Tell any passengers in the car to stay calm, stay still, and let you handle the conversation. When the officer reaches your window, you'll typically be asked for your license, registration, and proof of insurance. In most states, you are required to provide these documents when lawfully stopped, and this is not the moment to test the boundaries of what you're required to do. This is the moment to be as cooperative and calm as the situation allows, because cooperating with lawful, routine requests costs you nothing and creates a foundation for the encounter that's far more manageable than the alternative. Before you reach for documents in your glove box, in your center console, or anywhere else, it's genuinely worth saying something simple and direct, like, "My registration is in the glove box. I'm going to reach for it now." Just a brief verbal description of what you're about to do before you move. It sounds almost unnecessary when you're reading it calmly in a chair somewhere. It is not unnecessary in the moment, and officers will tell you the same thing. While you're handling this part of the stop, keep the conversation simple. Answer questions about your license and registration. Be polite. Don't volunteer information beyond what's asked, because here's a thing that's important to understand. You have the right to remain silent during a traffic stop, broadly speaking, beyond providing the identification documents required by your state's laws. Officers may ask questions. Where are you headed? Where are you coming from? Do you know why I pulled you over? And these questions, while they may feel obligatory, are generally not ones you're legally required to answer. "I'd prefer not to answer questions" is something you can say politely, without legal consequence. And it's worth knowing that even before you decide whether you want to use it in any given situation, knowing the option exists is different from always exercising it. Now let's get to the moment that this entire video is about. The moment the request to search comes up. There are two ways this tends to happen. The first is a direct, upfront request. Do you mind if I take a look in your car? Or, can I search your vehicle? The second is something softer and more conversational, almost casual. You got anything in there I should know about? Or, mind popping the trunk for me? Both of these are, underneath the different surfaces, the same thing, an invitation for you to consent to a search. And both of them deserve the same response. Here is the exact phrase, the one this entire video has been building toward, the one you want sitting in your mind before you ever need it. I don't consent to searches. That's it. 4 words. I don't consent to searches. Not, I'd rather not. Not, I'd prefer if you didn't. Not, I don't really think that's necessary. Not a long explanation of why. Not an apology. Not a question about why they're asking. 4 words, delivered calmly, without aggression, without hostility, without any of the edge that would make the interaction harder than it has to be. 4 words that accomplish exactly one thing. They make unmistakably clear, for the record, that whatever happens next was not something you agreed to. Now let's talk about what often happens immediately after those 4 words, because this is where most people buckle, and where the preparation matters most. The officer may say, "If you have nothing to hide, why wouldn't you let us take a look?" This is one of the most common responses, and it's worth having a clear, settled sense of why this particular question doesn't actually change anything. The premise embedded in the question, that refusing a search implies guilt, is not how the law works. The Fourth Amendment protects everyone, not just people who have something to hide, and exercising a constitutional right is not evidence of anything. You can respond simply and calmly. I understand why you'd say that, but I'd still rather not consent. That's a complete answer. You don't need to argue the constitutional theory from the driver's seat. You just need to hold the position. The officer may say, "It'll only take a minute. We just want to make sure everything's okay." The time something takes doesn't change what it is. A search is a search, whether it takes 30 seconds or 30 minutes. I understand, but I still don't consent to a search, is the response. Calm, consistent, firm. The officer may say, "If you don't let us search, we'll just get a dog out here and wait for it to alert." This one deserves a real answer, because it sometimes catches people off guard, and they're not sure what to say or what it actually means. There are a few things worth understanding. First, whether officers can detain you while waiting for a drug detection dog is actually a contested area of the law. The Supreme Court has addressed it in a meaningful way, holding in a case called Rodriguez v. United States that officers generally cannot extend an otherwise completed traffic stop for the purpose of conducting a dog sniff without independent reasonable suspicion that criminal activity is afoot. The stop should end when its purpose has concluded, not be stretched indefinitely waiting for additional tools to arrive. Second, a dog alert, even if it happens, is not the same as your consent. It's a different legal pathway entirely, and one that can be challenged in court on its own grounds. Third, and most practically, the threat that a dog might be brought does not mean you should give consent to avoid it. If anything, the existence of that as an option is separate from your decision about consent, and your decision about consent remains the same regardless. "I understand and I still don't consent to a search" is still the right sentence. The officer may say, "We're going to search it anyway." This is the scenario where people feel most helpless, most uncertain about whether their refusal even mattered. Here's what to understand. If officers search your vehicle without your consent and without a legal justification, no probable cause, no valid exception, that search may be constitutionally problematic, and that's a determination that belongs in a courtroom with an attorney, not in a roadside argument with an officer who's already made a decision. Your job in this moment is not to physically prevent the search, not to argue, not to escalate. Your job is to stay calm, to state clearly, one more time, for the record, "I don't consent to this search," and then to let what happens next be something that an attorney can examine later from a position of having preserved your rights to the maximum extent possible. You cannot unconsent to a search you've already agreed to. You cannot take back words you've already spoken. But you can absolutely decline clearly and let the legal consequences of whatever happens next be something that belongs to a proper legal setting rather than a roadside confrontation. Let's talk about probable cause specifically, because this is the concept that sits right behind almost every question about what officers can and cannot do with your vehicle without your consent. Probable cause is not a feeling, not a hunch, not a general sense that something seems off. It's a legal standard. specific, articulable facts that would lead a reasonable person to believe that a crime has been committed or that evidence of a crime is present. Plain sight marijuana, a weapon in visible reach, the smell of alcohol, specific and detailed information from a reliable source. These are the kinds of things that can establish probable cause. And if probable cause exists, the search doesn't require your consent, because it's justified by a different legal pathway entirely. Understanding this helps you understand the landscape of what you're actually navigating. If you declined a search and an officer conducted one anyway, one of two things is true. Either they had probable cause or some other recognized exception, and the search may be legally justifiable regardless of your refusal, or they didn't, and the search may be challengeable. Either way, your refusal matters, because it removes consent as a justification for the search, ensuring that whatever legal standard actually applied is something that has to be examined honestly, rather than avoided entirely because you agreed, and the question never came up. Let's talk about the exceptions to the warrant requirement for vehicle searches, because understanding these is part of understanding the full picture. Courts have recognized several circumstances under which a vehicle search can happen without consent and without a warrant, and it's worth knowing what they are so you're not caught off guard by something that feels wrong but may actually be legally justified. The automobile exception is probably the most significant and most frequently encountered, because vehicles are mobile, because they can be driven away before a warrant is obtained. Courts have held that officers who have probable cause to believe a vehicle contains evidence of a crime can search it without first obtaining a warrant. This is a real, well-established exception, and it applies broadly across the country, though the exact scope varies somewhat by state. If officers have probable cause, your refusal of consent doesn't prevent the search. It just removes your agreement as the legal justification, leaving probable cause as what has to be examined and defended. Search incident to arrest is another recognized exception. If you're lawfully arrested, officers can search the areas of the vehicle within your immediate reach, though the Supreme Court's decision in Arizona v. Gant significantly narrowed how broadly this applies. Officers can't simply search your entire car incident to an arrest if you're already secured and pose no realistic threat and can't access anything in the car. The scope of this exception has contracted meaningfully over the years, but it remains a real category worth understanding. Inventory searches are a third recognized category. If your vehicle is being lawfully impounded, towed from a scene, officers can conduct what's called an inventory search of the contents, ostensibly to document and protect the owner's property. This is also a real exception, though one that has boundaries around what it can actually be used for. The takeaway from all of this is not that the exceptions swallow the rule. The rule, that you have a Fourth Amendment right protecting your vehicle from unreasonable searches, is real and meaningful. The exceptions exist, but they have boundaries, and those boundaries are exactly the kind of thing courts examine, attorneys argue about, and judges rule on. Your job at the side of the road is not to adjudicate which exception might apply. Your job is to preserve your rights to the maximum extent possible in the moment, and the way you do that is by declining consent clearly, staying calm, and leaving everything else to be sorted out in the proper setting. Let's talk about what to actually say in a handful of specific situations, because I want you leaving this with real, usable sentences, not just a general understanding of the principle. If an officer asks, "Do you mind if I search your car?" the response is, "I don't consent to searches." Calm, clear, complete. No elaboration needed. If they follow up with, "Why not? Do you have something in there?" the response is, "I'm not trying to be difficult. I just prefer not to consent to searches." No argument, no long explanation. Polite, consistent. If they say, "We can do this the easy way or the hard way," the response is, "I'd like for this to be as easy as possible, and I still don't consent to a search." You're not choosing difficulty. You're exercising a right. Those are different things. If they say, "Your buddy told us you've been driving around with stuff in the car," the response is still, "I don't consent to searches." What someone else may have said, whether true or false, doesn't change your answer about consent. It might change what legal authority officers actually have. If there's reliable, specific information, it might start to approach probable cause territory. But it doesn't change your answer about consent, because your answer about consent is not about whether there's anything in the car. It's about whether you're authorizing officers to look, and the answer to that remains consistent regardless of what you've been told motivated the request. If they say, "Just step out of the car for a second," understand that officers can legally order you out of your vehicle during a lawful traffic stop, under a Supreme Court ruling called Pennsylvania v. Mims. This is within their authority, and complying with it is the correct call. Stepping out of your car when asked is not the same as consenting to a search of your car, and those are two completely separate things. You can step out calmly, keep your hands visible and away from your body, and when the moment comes, still say, "I don't consent to searches," if and when that request appears. If they ask whether there are any weapons in the vehicle, understand that this is a safety question and answer it truthfully, because the intersection of weapons and a traffic stop involves different considerations than the general question of whether you'd like to consent to a search. And honesty about a legally possessed firearm, for example, is almost always the better path than a misunderstanding or undisclosed discovery that changes the entire nature of the encounter in the worst possible way. Let's talk about what to do if you have a passenger in the car, because this adds a real layer of complexity. Passengers have their own rights. They can be asked for identification in many states, they can be ordered out of the vehicle, but they also have their own voice in this encounter. And it's worth understanding that a passenger expressing their own refusal of consent, or alternatively, a passenger volunteering that officers can search, creates a messier situation than if the driver and passengers are clear and consistent. If you have someone in your car, and you believe this video's framework matters, it's worth having that conversation before there's ever a reason to have it under pressure. If we ever get stopped and they want to search, here's what I'm going to say. Is a 5-minute conversation that can save an enormous amount of chaos later. Let's talk about the aftermath, because what you do in the minutes immediately after the stop ends is genuinely important, maybe more important than people expect, and it's something that rarely gets discussed in these conversations. The moment the stop is over, as soon as you're safely driving again or safely parked somewhere quiet, take out your phone and make a voice memo, or pull over immediately if you can, and write notes while everything is fresh. Capture everything you can remember: the time and location of the stop, the reason the officer gave for pulling you over, the officer's name and badge number if you caught it, or the patrol car number, exactly what was asked about searching the vehicle, exactly what you said, whether a search happened, and what specifically officers looked through if it did, and anything that felt notable or unusual about the encounter. Memory degrades faster than people expect, and the specific words, what was asked, what you answered, what happened next, are exactly the kind of details that matter enormously if this stop ends up being connected to anything later. Your own contemporaneous notes, made as close to immediately after the encounter as possible, become genuinely valuable documentation, and they cost you almost nothing to create. If a search happened that you believe was improper, if officers searched your vehicle after you clearly declined, and you're not certain what legal justification they could have had, talk to an attorney as soon as possible. Don't wait. Don't assume it'll work itself out. The window for challenging an unlawful search is real, and the earlier you get proper guidance about what your options look like, the better position you're in to actually exercise them. Let's talk about a scenario that comes up frequently and that people often aren't sure how to handle. What happens when you're not being pulled over for a moving violation, but for something equipment-related, like a brake light being out, and the stop feels like it was pretextual, meaning the equipment violation was just a reason to make contact when the real interest was in something else entirely? Courts have generally held that if an officer has a valid legal reason to make a traffic stop, even a minor equipment violation, that stop is lawful regardless of what else the officer might have been thinking or hoping to find. This is known as the pretext stop doctrine, and it's well-established law from a case called Wren v. United States. The existence of a legitimate traffic violation, however minor, generally makes the stop itself lawful. This doesn't mean anything else that happens during the stop is automatically lawful, and it doesn't mean your Fourth Amendment rights evaporate because you had a headlight out. But it does mean that arguing about whether the stop itself was legitimate is almost never the productive fight in the moment. The productive focus in the moment is exactly what we've been talking about throughout this video: what happens after the stop is made, and specifically, the question of searching your vehicle. Let's talk about something a lot of people wonder about but rarely ask directly. Does declining a search make the officer more suspicious? Does it make the stop harder, longer, more intense? And honestly, the truthful answer is that it sometimes does make the encounter slightly more extended, and it sometimes does create a bit more friction than a completely compliant interaction would. And I think it's worth being honest about that rather than pretending the choice is entirely costless in terms of the immediate experience of the stop. But here's the thing worth putting alongside that honest acknowledgement. The reason to decline consent to a search has nothing to do with making the encounter more comfortable in the moment. The reason is about where you are afterward, what has and hasn't been consented to, what rights have and haven't been waived, what questions an attorney can and can't raise later, if anything about the stop ends up mattering to you. The momentary comfort of a smoother stop, the 3 or 5 minutes you might save by saying yes immediately, is not a good trade for something that might matter in a situation where it actually matters. And the thing about rights is that you don't usually know in advance which situation is the one where they'll matter. You only know whether you had them or gave them away. Let's talk about recording, because this is another piece of this topic that deserves real attention. In most states, you are allowed to record your interactions with law enforcement in a public setting, including during a traffic stop. This is an area where state law varies more than some of the other topics in this video. There are questions about one-party versus two-party consent for audio recording in different states, but the broad principle, supported by federal appellate courts in most circuits, is that you have a First Amendment right to record police performing their duties in public. A dash camera is arguably one of the most practical tools available for this purpose because it's passive, it runs automatically, and it creates a continuous record of what happens without you having to make a decision about recording in the moment, with everything else going on. If you have a dash camera, know where its coverage begins and ends, and know that the footage it captures can be important documentation if anything about a stop ever becomes a matter of dispute. If you're recording on your phone, doing so openly rather than covertly is generally the cleaner approach, and stating calmly, "I'm going to record this interaction at the start of the stop," while keeping both hands visible, is a reasonable way to handle it. Let's talk about something related that deserves its own brief attention. What happens if an officer asks to see your phone, or asks whether you have any photos or videos of something they're investigating? Your phone is your phone, and the Supreme Court addressed this directly in a case called Riley v. California, holding that officers generally cannot search the data on your cell phone incident to arrest without a warrant, because the digital information on a phone is qualitatively different from other physical items and deserves stronger protection. If an officer asks to look at or through your phone during a traffic stop, "I don't consent to a search of my phone," applies just as directly and clearly as it does to your vehicle, for the same reasons and with the same calm firmness. Let's talk about what changes, and what doesn't, if you're someone who carries a legally licensed firearm in your vehicle. The presence of a legally possessed firearm in your car doesn't change your Fourth Amendment rights. It doesn't change whether you can or can't decline a search. It doesn't change the legal framework in any of the ways we've been discussing. What it does change is the practical dimension of the encounter, specifically around disclosure. Many attorneys and law enforcement trainers both recommend disclosure of a legally carried firearm early in the stop, before the question ever has a chance to come up in a surprising or ambiguous way, simply because the discovery of a weapon that wasn't disclosed creates an entirely different dynamic from a disclosure that happened calmly and clearly at the start of the encounter. "I want to let you know I have a legally licensed firearm in the vehicle," is not consent to search the vehicle. It's information that removes a potential source of tension and surprise from an encounter that goes better for everyone when tension and surprise are minimized. This is one of the areas where state law genuinely matters and varies, with some states having specific legal requirements around disclosure of carried firearms during a traffic stop, so understanding what your state specifically requires is worth doing as a separate matter. Let's talk about what happens after a search. If officers search your car and find something, or find nothing, and you want to understand what your options look like. If they search with your consent and find something, that consent is a very significant factor in the admissibility of whatever they found, and the ability to challenge that search later is substantially compromised by the fact that you agreed to it. This is perhaps the most concrete reason the question of consent matters as much as it does. It's not abstract, it's not theoretical, it's the difference between having a real legal argument available and not having it available. If they search without your consent and without a valid legal justification and find something, the exclusionary rule, the legal principle that evidence obtained in violation of the Fourth Amendment can be suppressed in court, is exactly the rule that an attorney can use to challenge whether that evidence can actually be used against you. It doesn't guarantee a particular outcome, and the exclusionary rule has exceptions of its own, but it is a real, meaningful tool. And it only exists as an option if you didn't give away your rights by consenting before the search happened. Your refusal is the thing that keeps that door open. Let's talk about the moment after the search, if one happens, when the officer is handing your documents back and either writing you a ticket or telling you you're free to go. This moment, as simple as it sounds, has a question embedded in it that matters. Are you actually free to go? You're allowed to ask. Am I free to go is a question you can ask at any point in the stop when you genuinely aren't certain, and the answer tells you something important about where the stop actually is legally. If the officer says yes, you're free to go, then you're free to go. You thank them, you leave calmly, and you're done. If the officer says no, and you're still being detained, then you're being detained, which means there needs to be a legal basis for that continued detention, and that's something that can be examined if it matters later. Knowing whether you're free to go and asking directly when you're uncertain is not aggressive or provocative. It's simply clarifying your situation so you can make informed decisions about what to do next. Let's talk about one scenario that comes up in these conversations frequently and genuinely confuses people. What happens if officers call in a drug-detecting dog and the dog alerts on the vehicle? A dog alert, if it happens, can establish probable cause for a search in many situations, and a dog alert is not something you consented to by refusing a search request. They're different things. The question of whether a dog was used properly, whether the alert was genuine and well documented, whether the stop was unlawfully extended to accommodate the dog's arrival, are all questions that can be examined and challenged in the right setting. What's important to understand is that a dog alert doesn't become your fault for declining consent. Those are entirely separate pathways, and the potential availability of one pathway to search your vehicle doesn't mean you should remove the protection that comes from refusing the other. Let the dog alert, if it happens, be its own separate question, and let it be examined on its own terms. Let's talk about something emotional that sits underneath all of this, because I think acknowledging it honestly is part of giving you something genuinely useful, rather than just a list of legal concepts that feel disconnected from the actual experience of being pulled over. There's a very human and very understandable experience that happens during a traffic stop, which is that your body knows something is at stake before your brain has caught up to processing exactly what it is. Your heart rate goes up, your hands maybe get a little unsteady. Your mind starts running ahead, trying to anticipate what's coming, what you should say, what expression is appropriate for your face right now. And in that state, the easier path, saying yes, being accommodating, getting through this as quickly as possible, is not just the path of least resistance socially. It genuinely feels like the safer path, like the one that leads to this ending faster and more smoothly, and without whatever unknown thing might happen if you push back on anything at all. That feeling is real, and it's worth knowing in advance that it exists, and that it's going to be present in that moment, because the only real defense against it is having the right answer ready before you're in the situation, so that when the question comes, you're not inventing a response from nothing, while your hands are slightly unsteady on the steering wheel. You're recalling something. You're using a sentence you already know. I don't consent to searches. 4 words you've already said 100 times in your head, and they come out calmly and clearly because they were already there waiting. Let's talk about passengers one more time, because there's something specific here worth circling back to. If you're a passenger in someone else's car and you want to understand your own position in that encounter, there are a few things worth knowing. As a passenger, officers generally can ask for your identification in some states but not others. This is genuinely one of the more variable areas by state, and knowing your state's specific rule is useful here. As a passenger, you can be ordered out of the vehicle, the same as the driver. As a passenger, you have your own Fourth Amendment rights regarding your own person and your own belongings. A search of a bag that belongs to you specifically, for example, isn't automatically justified just because the driver consented to a general search of the vehicle. The ownership and reasonable expectation of privacy around specific items matter, and this bag is mine and I don't consent to it being searched, is something you can say as a passenger, even if the driver is agreeing to a broader search of the vehicle. And if you're ever a passenger in a stop that involves a search, and you have any concern about whether your rights or your property were handled correctly, talking to an attorney is just as available to you as it is to the driver. Let's talk about the broader context of why this matters. Because sometimes in conversations like this, the practical details feel disconnected from anything bigger, and I think connecting them to something bigger is actually part of what makes them stick. The Fourth Amendment was written by people who had lived under a system where officials could enter your home or stop you on the road and search through your belongings without any particular justification, without any meaningful legal check on that power. They built the Fourth Amendment specifically because they had experienced what a world without that protection felt like, and they decided that kind of world was incompatible with the kind of country they were trying to build. The right to be free from unreasonable searches isn't a technicality or a loophole. It's one of the foundational commitments of this country, specifically because its founders understood what it meant not to have it, and exercising it. Saying, "I don't consent to searches," at the side of a road on a Tuesday afternoon is not a way of being difficult or suspicious or unpatriotic. It's a way of treating a protection built into the fundamental law of this country as the real, meaningful thing it actually is, and making sure it applies to you the same way it applies to everyone else, because that's what it was built to do. Let's do something specific before we close that I think will actually be useful. Let's say the phrases out loud right now, in full, because there's a difference between reading words on a screen and having them sitting in your muscles a little bit, in the actual physical experience of having said them. So say this with me, or say it to yourself, or say it out loud right now wherever you are. I don't consent to searches. I'd prefer not to answer questions. Am I free to go? I don't consent to this search, but I won't physically interfere. 4 sentences. Simple, complete, warm in tone, firm in substance. Those are the 4 sentences this entire video lives inside. Those are the 4 sentences that, depending on which one is relevant in any given moment, preserve everything the Fourth Amendment was built to give you, without aggression, without argument, without anything that makes the encounter harder than it needs to be. The 4th sentence especially, "I don't consent to this search, but I won't physically interfere," is worth understanding specifically, because it's the sentence for the situation where officers are going to search, regardless of what you say, either because they believe they have probable cause or because they're making a mistake. It accomplishes 2 things simultaneously. It puts your non-consent on the record clearly, so it can never be characterized as agreement, and it signals clearly that you're not going to create a physical confrontation, so that the encounter doesn't escalate into something that creates additional problems on top of whatever legal questions already exist. It's the sentence for when you've done everything right, and the situation is still going somewhere you didn't choose. And having it ready in advance, knowing it cold, is exactly what makes it possible to say it calmly, in a moment that is anything but calm. Let's talk about what happens in the days and weeks after a stop if you think something about it wasn't right, because this is where preparation and documentation pay off in the most concrete way. If you wrote down your notes immediately after, if you have dash camera footage, if you remember specific details about what was said and what order things happened in, you have something to bring to an attorney that's actually useful. General impressions and approximate memories are less useful than the specific, contemporaneous account you created in the minutes after the stop ended. Attorneys who do this kind of work, who focus on civil rights, criminal defense, Fourth Amendment challenges, are the right people to assess whether what happened to you crossed a legal line, and they can only assess it well if you give them something specific and detailed to work with. The documentation step is the step between, "I think something might have been wrong," and "here's exactly what happened and when, and who said what." And that step is something only you can take. Let's talk about one more scenario, one that doesn't come up every time, but comes up often enough to be worth addressing directly. What happens if the stop was for something serious? Not a brake light, not a lane change, but something that already involved an accusation or a claim, and the request to search the car comes in that context, rather than the context of a routine traffic encounter. The same principle applies. In fact, in that context, the principle applies even more emphatically, because the stakes of what might be found or not found are potentially higher, and the importance of preserving your rights rather than waiving them, in the hope that cooperation will lead to a better outcome, is even more important to hold on to. The hope that cooperation will earn you better treatment is understandable, but it's not a reliable strategy, and it trades something real and recoverable, your right to require proper legal justification for a search, for something speculative and unguaranteed. Hold the line. "I don't consent to searches" applies regardless of what the stop is about, because the protection doesn't shrink based on the seriousness of the accusation. If anything, the more serious the context, the more important the protection becomes. Let's close by pulling everything together one more time. clearly and completely, because I want the framework sitting in your mind organized and ready, rather than scattered across everything we've covered. You have a Fourth Amendment right protecting your vehicle from unreasonable searches. Without a warrant, without probable cause, without your consent, officers generally cannot search your car. When they ask, and if they're asking, it's because they need your answer to be yes. The answer is, I don't consent to searches. That sentence is delivered calmly, without aggression, without lengthy explanation, and it's held consistently regardless of what follows it, because consistency is what makes it meaningful. You provide your license, registration, and insurance when asked, because those are lawful requirements. You step out of the vehicle if asked, because that's within an officer's authority during a lawful stop. You keep your hands visible, you stay calm, you keep your voice level, and you say those 4 words when the moment comes. If a search happens anyway, you state clearly that you don't consent and that you won't physically interfere, and then you document everything immediately afterward and talk to an attorney if anything about it seems wrong. If the stop ends normally and you drive away, you document it anyway, briefly, just so you have it. The preparation happens now, in whatever calm moment you're currently sitting in, specifically because you want those words to be second nature, rather than something you're constructing from scratch under pressure at the side of a road. Not panic, not paranoia, not an assumption that every stop is hostile or that every officer is acting in bad faith. Most stops are routine, most officers are professional, and most of the time the question never even comes up. But if it does come up, you're ready. You know exactly what to say, exactly why it matters, and exactly what it protects, and that readiness is yours to have regardless of whether you ever actually need it. The right exists whether you know about it or not. Knowing about it is just what makes it actually yours in practice, rather than only yours on paper. If this gave you something solid that you didn't have as clearly before, subscribe right now, because this is exactly the kind of preparation this exists to provide, one real scenario at a time, with the actual words and the actual reasoning, rather than the general version that.
All right, that's where we'll leave it for today. I hope this gave you something genuinely useful, not just interesting to hear, but something you could actually use if the right situation ever came up. That's always the real goal here, understanding you can actually carry with you, not just information you forget by tomorrow. Take care of yourself, know what's actually yours, and I'll see you in the next one.